The problem is not too much money in politics. The problem is too much power in government. The government regulates everything, and of course people want to affect the course of the government. So the campaign finance reformers, ultimately what they want to prevent is that. It's the ability to affect the course of our government. It's the ability to affect which way people vote. That's the dirty little secret of campaign finance law. They don't just want to control money, they want to control speech.
In 2008, Citizens United produced a film called Hillary the Movie. The documentary was clearly intended as a feature-length attack on the presidential aspirations of Senator Hillary Rodham Clinton. The Federal Election Commission, saying the film's broadcast would violate federal election law, shut down the pay-per-view broadcasts of the film on cable services. If the government believes it can ban the pay-per-view broadcast of a movie, what else might the FEC try to ban under the First Amendment and current federal election law? The High Court tried to find out when it heard the case on March 24, 2009. Questioning the government's lawyer, Chief Justice Roberts said, so if Walmart airs an advertisement that says,
"We have candidate action figures for sale. Come buy them,"
that counts as an electioneering communication? Malcolm Stewart, Deputy Solicitor General, responded, if it's aired in the right place at the right time, that would be covered.
The law says that a corporation can't run an advertisement that depicts a candidate within a certain time of primary or election, and that's what the law says.
Here the court is trying to discover the limits on government. The surprising answer they got was that there are no limits on government.
The ad Chief Justice Roberts described did not advocate the election or defeat of any candidate. It was just an ad for a product. If movies broadcast on cable or advertisements for action figures can be regulated or banned, what about books?
A book that expressly advocated the election or defeat of a candidate today would fall outside what the FEC thinks it ought to be able to regulate, because it would be news commentary or an editorial. But there's nothing that says that Congress can't bring that interpretation back in and restrict it just like it would restrict a campaign ad.
In fact, Stewart said during oral argument, because the First Amendment refers to both freedom of speech and of the press, there would be a potential argument that media corporations, the institutional press, would have a greater First Amendment right.
Isn't it amazing that the Solicitor General before the U.S. Supreme Court could imply that the institutional press has greater First Amendment rights than everyone else?
The government's lawyer's point was that the government has plenary powers in this area, really. Now, true, they might carve out exemptions, but they would do so to avoid embarrassment, to avoid making it clear that the First Amendment is really constrained, that government isn't really limited by the First Amendment.
There's an exception currently for newspapers, but that can't last. It's illogical if you accept the premises of the campaign finance laws.
Chief Justice Roberts asked, if it has one name, one use of the candidate's name, it would be covered, correct? Mr. Stewart responded, that's correct. Chief Justice Roberts said, it's a 500-page book, and at the end it says, so vote for X. The government could ban that? Mr. Stewart responded, well, if it says vote for X, it would be express advocacy, and it would be covered by the pre-existing Federal Election Campaign Act provision.
It would seem counter to the First Amendment that you could ban books because they're too political. But what we've got here is a government that has decided that some kinds of political speech are dangerous. They're dangerous because they allow influential groups to talk about politics in ways that might hurt incumbents and might hurt entrenched interests.
If the government can ban publication of a book, what limits are there really on the federal government?
When the government is taking the position that they can ban books, it's time to scrap the campaign finance laws. This is America. We don't ban books here.
So what about new forms of communication? Justice Kennedy asked, and I suppose it could even, is it the Kindle where you can read a book? I take it that's from a satellite, so the existing statute would probably prohibit that under your view? Mr. Stewart responded, well, the statute applies to cable, satellite, and broadcast communications.
He's looking at a Kindle and he's saying, it's a book, but it must be prohibited because it's a broadcast communication, and under the law we regulate broadcast communication.
So what should the public be willing to accept if they oppose allowing so-called big money, often corporate money, to get into politics?
They have to be willing to accept the idea that the government gets to choose how people finance speech, which is to say what kind of speech, when and how and where can be stated. They have to be willing to give up, in the end, I think, the First Amendment right to truly free speech.
Books will inevitably be banned if we continue in the same direction that we are. Movies will have to be banned, and frankly, I think newspapers ultimately will have to be banned as well.
It's inevitable that once you start regulating political activity, you are going to run roughshod over people's First Amendment rights. There's just no way around that.
It's only logical that if we can prevent advertisements from being run, we can prevent all types of speech from being run. In fact, this very film could be banned as well.